Green cards are being denied at record speed. Citizenship cases rejected for reasons most applicants never even saw coming. What's behind this sudden wave of denials? And could your own case be next? This is Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. Today, we break down 4 hidden reasons behind the rise in green card and citizenship denials. We'll explain the mandatory versus discretionary standards that USCIS officers now use, and the simple mistakes that can destroy an otherwise strong case. Stay tuned, because one small error could mean a permanent denial. Across the U.S., immigration attorneys are seeing a disturbing trend. Applicants with years of clean records suddenly receiving denial letters. It's not just because of missing paperwork or late forms anymore. In 2025, USCIS officers have broader discretion to deny applications, even when basic eligibility is met. These denials fall under 2 categories: mandatory denials, which are automatic and legally non-negotiable, and discretionary denials, where the officer uses judgment based on your overall record. Let's break both down and how to protect yourself. Reason number 1: mandatory denials, the non-negotiable roadblocks. Some cases are doomed the moment they're filed.
Why?
Because the law simply does not allow approval, no matter who reviews it. These are statutory bars written directly into immigration law. If you fall under one, the officer has zero discretion to forgive or overlook it. Common mandatory denial triggers include aggravated felonies or serious criminal convictions, false claims to U.S. citizenship, immigration fraud without a waiver available. If any of these apply, the case must be denied, even if you've lived in the U.S. for decades. Here's the trap. Many applicants don't realize their past issues make them ineligible. They hire unqualified notarios or fill out forms online without review. Then, when they attend the interview, it's already too late. Once a mandatory issue appears on record, the officer has no choice but to deny and sometimes even refer the case for removal proceedings. So before applying, get a background review. Request your FBI record, court dispositions, and immigration history. Never assume a past issue is cleared just because it's old. Mandatory denials are permanent and preventable only if you prepare early. Reason number 2: discretionary denials, when officers have the final say. Even if you meet every requirement, your case can still be denied. This is called discretionary denial, and it's more common than ever. Under USCIS policy memos updated in 2024 and early 2025, officers have expanded authority to weigh your character, behavior, and past conduct. They now consider a prior immigration violations or unauthorized work, repeated traffic offenses, negative public behavior, a lack of community involvement. Even something small, like unpaid taxes or reckless driving, could raise doubts about your good moral character. This doesn't mean you'll be denied automatically, but the officer can weigh negative factors against positive ones, like family ties, volunteer work, or long-term residence. The key is to build a strong positive record. Provide community letters, tax compliance proof, and evidence of rehabilitation if needed. Remember, discretionary denials are about how your story looks overall, not just the documents. Reason number 3: minor mistakes, major consequences. You'd be surprised how many denials happen for tiny, avoidable reasons. A missing signature, a mismatch in dates, an unreported arrest that was dismissed years ago. These minor missteps can trigger suspicion and sometimes a full denial. Let's say you had a youthful arrest that was expunged. Even if it's off your record, USCIS can still see it and question your character. Or maybe you accepted a public benefit you weren't eligible for, even unknowingly. That can be viewed as a negative factor during discretionary review. Officers are trained to look for inconsistencies. If your story doesn't match your paperwork, that's enough to raise a red flag. Always double-check everything before filing. Submit affidavits explaining past issues clearly. If anything could be misunderstood, clarify it upfront rather than waiting for an interview. The smallest mistake can undo months of effort. Reason number 4, documentation rules. Green card versus citizenship. Many applicants don't realize the document requirements differ between a green card and citizenship, and 400. For green card applicants, USCIS reviews your entire lifetime record. They can go back decades, even to activities overseas, when deciding eligibility. For citizenship, the focus is usually on the past 5 years, or 3 if you're married to a U.S. citizen. But the documentation rules are stricter. For example, if you've ever been arrested, even if not convicted, you must provide certified court records, not just police reports or copies. If something's missing, USCIS won't hesitate to deny your case outright. In 2025, interview officers are paying close attention to incomplete or uncertified records. So gather everything early. Certified dispositions, IRS transcripts, tax records, employment history, all must be accurate and consistent. Knowing what USCIS expects for your specific application type can be the difference between approval and denial. What this means for you. The message is clear. USCIS is tightening every screw. The margin for error has never been smaller. Denials aren't just numbers. They can lead to serious consequences like a loss of filing fees, referral to immigration court, a long-term eligibility bars. But the good news? Every one of these issues can be prevented with preparation and documentation. Before filing, review your full history. Seek legal advice if you have any criminal or immigration violations. Present a strong narrative showing good moral character and community contribution. Preparation isn't optional anymore, it's survival. Real-life scenario. One applicant applied for citizenship after 10 years as a green card holder. He had a dismissed DUI from 2016, but didn't include the court record. The officer denied his application, citing failure to establish good moral character. Had he submitted a certified record and an affidavit of rehabilitation, it likely would have been approved. This happens every day. Don't let it happen to you. Mandatory denials, they're automatic and final. Discretionary denials, they depend on your record and behavior. Minor mistakes, they can derail your case fast. And documentation errors, they're now one of the top reasons cases are rejected. Every form, every signature, every supporting paper now carries weight. In 2025, USCIS officers are under tighter review standards, and that means your file must be absolutely clean. A small oversight, a missing certified record, or a forgotten explanation can undo years of effort. So don't rush your application. Review everything twice. Seek legal advice if your past includes any arrests, immigration violations, or visa overstays. Build your positive record with tax filings, employment history, and community involvement. The truth is, denials aren't random. They follow patterns. Those who prepare early, document everything, and tell their story clearly have the highest chance of success. Know the rules before you file. Prepare like your future depends on it, because it does. Your approval isn't luck, it's strategy. If you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching Immiscope, your trusted source for U.S. immigration news, policy changes, and visa updates. See you in the next video.